We recently won a major verdict in a lawsuit involving a condo association. Hi, I'm Jane Muir, and I'm a Miami business lawyer. You might have heard on the news about a condominium in the MiMo area of North Miami called the Palm Bay Yacht Club, because it was in the news about 2 years ago for having a major assessment of $48 million. And a group of homeowners who lived in this condominium and owned units retained us to sue the condo association over this crazy high assessment that was resulting in every unit owner having to pay $175,000. Well, we filed a lawsuit in Miami-Dade County, and the response from the association was that they needed to appoint a derivative investigator to determine whether the lawsuit had merit and should proceed past the pleading phase. This is not a standard process for a lawsuit. Usually what happens is once you've effectively explained what your claims are, the judge will allow you to continue and the opposing parties have to answer. In the setting of condominiums or homeowners associations, there's this bizarre option of having an investigator appointed, which kind of creates an issue where the association is recommending someone to do the investigation that they like and they believe it will rule in their favor. And the unit owners have to overcome this extreme requirement that no other type of lawsuit requires. Luckily for us, we were able to get through the investigation, and the investigator found that at least several of our claims deserved to be able to proceed in the litigation. And what he did was he carved off claims relating to an older construction project that was about a $3 million project from the primary work that was being done of $40 million for a 40-year recertification. And my clients and I still don't believe that that was the right result, but we have to go with whatever the court decides, and the court accepted this report. In any case, we went forward with the litigation against the former property manager called South Florida Condominium Management and a contractor called DNR Construction that had done a lot of unpermitted work. And in the end, the jury decided that we should recover a total of $5.8 million as to the condo management company, mainly because they had appointed an unlicensed person to serve as the condo manager of this apartment building. And then as to the contractor, we received an award of approximately $500,000, which is how we got to this $6.3 million verdict. Now it is March, and we received this verdict in December, and we're still working through the post-judgment motions that always are filed after a verdict. And so we have not yet seen a recovery from our verdict, but it is a significant result in the world of condominium because it's so unusual for a group of unit owners to succeed in light of all the hurdles that the system puts in your way when you're trying to sue the association. Going through this process for our unit owner clients was a real education because they wanted to enforce their rights under the declaration and under the statute. But what they learned in the end is that really going through the courts is very difficult, very expensive, very time-consuming. And in the end, when we win, the award that we recover will primarily go back to the association, which is led by the same people that they're opposed to in the first place. So based on this experience, I personally prefer to recommend to clients that they seek to lead their association through election or recall instead of suing the association, which is incredibly risky. And in the end, if you win, your results may be under the control of the people that you're opposed to in the first place.